Hi, everyone. Welcome to the video version of the cancel class that we were supposed to have on Wednesday, January 30th. I hope you're all someplace warm, maybe under a nice comfy blanket, or you got your long johns on. So what we're going to cover today is what we would have talked about in class, which is the in-class exercise involving persuasion through logic. And we're going to use the sample trial brief that I handed out to you during the first week of class as the basis for this discussion and walkthrough of the exercise. And we're going to focus on several different components of persuading through logic. We're going to talk about organization. We're going to talk about highlighting favorable information and de-emphasizing unfavorable information for the reader. And we're going to talk about a few other things that go along with persuasive writing that you may not have had to deal with when you were writing an office memo. Just to put you on notice, I'm going to try to remember to notify you when there are good pause points in this video. We're probably going to be, I'm guessing, at least 35 to 40 minutes with this video, so you probably want to break it up in chunks so you don't, so you can maintain good attention. So I'll try to notify you as to when there are good transition points where you can probably pause for a little bit, pause the video for a little bit, and then come back to it. So let me just give a little bit of background about the case that this sample trial brief involves. It's a negligence case. Specifically, it involves the liability of a landowner. The landowner in this case being the owner of a nightclub. You may or may not have discussed this in torts or in property law, but usually under most states' laws, and we're focused on Indiana law here, is that a landowner usually has a duty to take reasonable care for the invitees that visit the property. And an invitee, if you didn't know, is somebody who is on private property, but they're on private property because that private property has been held open to the public. And the perfect example is a store. Like you go to Kroger or you go to Whole Foods or whatever. Those places, even though they're technically on private property, are still held open to the public because they want people to do business there. So when you walk on the property, your status under tort law is that of an invitee. So we're focusing here in this case on a landowner, specifically a bar owner's duty to exercise reasonable care to prevent harm from befalling invitees on the landowner's property, on the bar owner's property. So in this case, fact-wise, in a nutshell, what happened is our client in this case, the defendant, Jillian Crystal, owns a nightclub that has bands play there every once in a while. The plaintiff is John Ritchie, is a member of a band who commonly played at Crystal's nightclub, which is called the Music Box. And one night after a show, Ritchie was attacked by another patron who was at the bar. They were standing outside on the sidewalk in front of the club, and they were attacked. And the other patron attacked Ritchie. And then Ritchie decided to sue Crystal, the bar owner, alleging that she was negligent because she was not fulfilling her duty to exercise reasonable care to prevent him from being injured. Now, normally that duty applies to the landowner's acts. In other words, the landowner can't do something that would endanger their patrons. That would be, in most cases, negligence. However, the defendant here, the bar owner, Crystal, wasn't the person who caused the injury. It was somebody else who was there. So we're talking about instances of when is it that a bar owner has a duty of care to protect people who are visiting their bar from other people who are visiting their bar. So that's what we have going on here. What I have before you is what you need to think about as a format for laying out the law when you are writing a persuasive argument, okay? And the way I like to think about it is an inverted triangle or an inverted pyramid, where you start with the broadest legal concept and then you narrow down until you get the most specific applicable legal concept. In other words, you start with the broadest rule and then you get to the narrowest rule that you're applying in the case. So in this circumstance, the broadest rule that if we were representing Crystal, the bar owner, that we would be writing about in this brief. And by the way, the brief is in support of a motion for summary judgment. After discovery has been conducted, the bar owner, Crystal, has filed a motion for summary judgment alleging that based on the evidence that has been gathered through discovery, she is not liable to Richie, and thus the court should grant her judgment without a trial. So in looking in that question, the broadest, most general legal concept that applies here, the broadest rule, is the negligence rule. And a major component of proving negligence for the plaintiff is that the plaintiff has to show that the defendant owes the plaintiff a duty to conform its conduct to a particular standard of reasonable care. Now, that duty of reasonable care owed by a defendant landowner to a patron who is on their premises, in other words, an invitee, is normally dictated by the relationship between the two. You know, what relationship do they have? So we get a little bit more specific then, and the next you'll see is that we start at the top of the triangle with the broadest rule, and then we get a little more focused rule when we're looking specifically at what duty of care a landowner owes to an invitee. And in that circumstance, it's usually based on the relationship between the landowner and the invitee, such that the plaintiff's injury must be reasonably foreseeable to the landowner. Okay, so if the landowner can't reasonably foresee the plaintiff's injury, then the defendant landowner has no duty of care, owes no duty of care toward the plaintiff. All right. So that's the little bit more focused, and now we get to see, how do we determine reasonable foreseeability? Well, we look at the circumstances surrounding the plaintiff's injury to determine whether the landowner owed a duty of reasonable care to the invitee plaintiff. And so this is our most specific rule. You know, what do you have to examine to determine reasonable foreseeability? Well, the court will examine the nature, condition, and location of the land. You see this at the bottom of the triangle. Whether there were prior similar incidents to the incident that gave rise to the plaintiff's injury, and whether the assailant, the plaintiff's assailant, in other words, the person who attacked the plaintiff, had done things on previous occasions that might have indicated they were a threat to the plaintiff. So those are the circumstances that you examine. So think about using this inverted triangle technique when you're laying out the law in your brief. Start with the most general rule that applies to your argument, and then narrow it down to the most specific rule that applies. And we're going to actually look at the sample brief here in a moment so you can see how this works in context rather than just looking at this graphic. All right, so actually, let's look at the sample brief. So I'm going to switch over to the sample brief here, and we're only looking at the argument section because, you know, in the exercise, what we wanted to examine, first of all, is the roadmap section. But before I get to the roadmap section, I want to talk, well, actually, let's look at the roadmap section first. Then we'll come back to the point headings in the large-scale organization. So the roadmap begins here in the first paragraph of the text. And actually, this particular roadmap for this brief, and this is Crystal's brief in support of her motion for summary judgment. So she's arguing in this brief that she is not liable because she did not owe Richie a duty to protect him from attacks by others who were at the bar. That's what her argument is. So one of the things we talked about when we talked about roadmaps is the concept of the motion standard. In other words, is there a procedural standard that you need to satisfy to win your motion? In this case, with summary judgment, there is. The defendant has to show that there's no genuine issue of material fact. In other words, that the important facts that would prove up the plaintiff's claim are not disputed by either party, that the parties agree on those facts. If the parties don't agree on those facts, then the court can't grant summary judgment because a jury should be the appropriate body to determine what those facts are. And then assuming that there are no issues of material fact, then the second thing is that the plaintiff has to be entitled to judgment. I'm sorry, the moving party, in which this case is the defendant, has to be entitled to judgment as a matter of law. All right, so that's the motion standard, and you see that that's discussed here at the outset of the roadmap. And I'm going to come back to this statement in a moment because I want to continue to talk about this roadmap to illustrate the concept of the, laying out the law in this inverted triangle format. So I'm going to unhighlight this just because you already know now that that is the motion standard. So your roadmap should state the motion standard. This one does. That's good. But the roadmap should also lay out the general legal principles. In other words, what's the general rule of law that the defendant here is applying to make her argument? And that's the negligence rule, specifically the duty of care. So if we page down here a little bit, that discussion of the law starts here. This statement that to prove this claim, meaning his negligence claim, Ritchie must show that Crystal owed Ritchie a duty to conform her conduct to a standard of care arising from her relationship with Ritchie. So that's the broadest rule here that we can apply. This case is focused on duty of care under a claim of negligence. So that's the broadest rule that we can apply. And then as we move into the next paragraph, we get a little narrower in that we're focusing on a landowner's duty of care, which, as I mentioned, is sort of the next narrowest related legal rule of law. So we state here that a landowner owes business invitees a duty to exercise reasonable care for their safety. So in general, if you're a bar owner, if you're a landowner and you have invitees on your property, because usually it's because you own a business and you're asking them to come on your property to buy your product or whatever, you owe them a duty to exercise reasonable care for their safety, which means usually that you as a landowner can't do anything that would be harmful to them. You have to take reasonable precautions to prevent injury because of what you've done. Okay, and then we get more specific in the next paragraph in that we're focusing in this circumstance a little more narrowly on when a landowner owes a duty of care to an invitee when the invitee's injuries are caused by not the landowner, but somebody else on the landowner's property. And that's this highlighted statement here. So again, we're getting a little more narrower with our statement of the rule that when an invitee's injury is caused by the criminal acts of a person besides the landowner owes a duty of care to the invitee only if the landowner could have reasonably foreseen the invitee's injury. So we're getting more specific here with what the law is, in that we're focusing on reasonable foreseeability. Reasonable foreseeability dictates whether the landowner has a duty of care to the invitee. And then finally, we get to the narrowest rule that we're applying here, which is this three-factor rule that determines when an invitee's injury is reasonably foreseeable to a landowner. To determine whether that injury is reasonably foreseeable, a court is going to have to examine the surrounding circumstance, which include the following three circumstances. So you see, this is a bit like the additional circumstances rule from the constructive possession case in the office memo that you wrote last semester. This is kind of a similar concept. So the circumstances that the court will examine to determine whether the invitee's injury was reasonably foreseeable to the landowner is the nature, condition, and location of the land where the injury occurred, whether there were prior similar incidents that resulted in injury on the landowner's property, and whether the invitee's assailant, in other words, the other person on the landowner's property who actually attacked the plaintiff, had done anything that would indicate to the landowner that that the assailant might be a danger in the future. So we examine the prior actions of the invitee's assailant either on the day of the act or on a previous occasion. So we have these three factors that are applicable. So that's our inverted triangle to illustrate that concept to you. All right. I think we're at a good pause point now that we've talked for a little bit. And so we're going to take just a momentary break here. I'm going to pause, and then we'll resume in just a moment. Okay, we are back. So the next thing I want to talk about is something that is a question in the Persuasion Through Logic exercise, and that's with regard to large-scale organization. In other words, is this argument organized in not only a logical way that the judge will be able to follow when the judge reads the argument, but is the global organization also done in a way that's designed to highlight, to emphasize the strongest points in the argument? All right, so we're going to examine this from the standpoint of the argument's point heading. So remember, you want to include point headings in your argument that signal your main conclusion that you want the court to reach, and that should begin your argument. And then you want to have a subheading for each supporting point of your argument. In other words, what are the supporting points of your argument? You need to have a heading for those to indicate to the reader where those supporting points are. And so this gives the judge a big picture snapshot of what your argument's going to be about. So I'm going to highlight the main heading here. So this is the main conclusion that Crystal wants the court to reach in this case, that she owed Richie no duty to protect him from Broad's attack and thus is not liable to Richie for negligence because the attack was not reasonably foreseeable. All right, that's actually a very good point heading. And so let's talk about the format first. So we talked about point headings should be in the conclusion because reasons format. So let me back up here with my highlighting, and we're going to talk about each one of those components. So the main heading here is, or the main conclusion that Crystal wants the court to reach is that she did not owe Richie a duty of reasonable care, and thus she was not negligent. Okay, so that's what this first part of the point heading does, is it emphasizes, it states the main conclusion. Crystal owed Richie no duty to protect him from Broad's attack and thus is not liable to Richie for negligence. So that's the conclusion part of the point heading. Then we have because, right? So because, and then we follow that with a brief summary of the reasons. And the brief summary of the reasons here is this back end of the point heading. Because the attack was not reasonably foreseeable. All right, this is a good point heading because it's a conclusion because reasons, it's properly focused, and then it focuses on the main conclusion, and it gives a good but brief summary of the reasons for that. All right, so this is the conclusion that your point heading should reach. So let's page down, and we're going to go to page 5 of the brief to look at the first point heading. Okay, so I want to back up a little bit and go back to the roadmap and highlight this most specific rule that we're going to apply here. So that's looking to see how we determine whether there's a duty. Duty is determined by reasonable foreseeability. Could the landowner have reasonably foreseen the invitee's injury? The invitee being the plaintiff here. To determine that, the court has to examine the surrounding circumstances, which include the following 3 circumstances: the nature, condition, location of the land, prior similar incidents, and the prior actions of the invitee's assailant on the day of the act or on a previous occasion. Okay. All right. So one of the things we want to look at here is how do we organize it? What are our supporting points? Well, one way to logically organize this in terms of supporting points is to have a subsection in the argument for each circumstance that are going to be argued. That seems like the most logical way to do this. So we would have a supporting argument for the nature, condition, and location of the land circumstance. We'd have a supporting argument for the prior similar incident circumstance, and we'd have a supporting argument for the prior actions of the assailant circumstance, which means logically we're going to have three subsections, right? So we'll go to subsection A. This is the first supporting point in the argument. So which circumstance are we focusing on here? Well, going back up to the rule, I'm going to unhighlight again. Going back up to the rule, we're going to focus on first, at least in this brief, is focusing first on the nature, condition, and location of the land, because this point heading is focused on the music box's location. This point heading states that the attack wasn't reasonably foreseeable because the music box was located in a neighborhood not known for violent crime. So you can see point heading wise, we have conclusions because reasons. Conclusion is not reasonably foreseeable because reasoning being we're focusing on the location factor. Okay. All right, we're going to come back to a discussion of whether that's the best supporting argument to lead off with. But I want to go to the second point heading here. This second point heading highlights the fact that the second supporting point of the argument is going to be they're going to focus on the prior similar incidents factor. Broad's attack was not reasonably foreseeable because the prior incidents at Crystal's Club were dissimilar from the attack. So this is circumstance number 2 of the reasonable foreseeability rule that we stated in the roadmap. So that leads to the third point heading for the third subsection, which is on page 8, and that's this one here. And this focuses on the last circumstance mentioned in the reasonable foreseeability test. Broad's attack was not reasonably foreseeable. That's conclusion because, and then summary of reasons. Broad's prior actions were too vague to indicate that Ritchie might be attacked. So this section of the argument is going to focus on the circumstance that addresses the assailant's prior actions. What were Broad, Broad is the assailant here. So what were Broad's prior actions? All right, so just to go back to the roadmap, so we're going to go all the way back to page, where are we here? Sorry about that. Page 4. Okay, so here is our rule again. And so what we have going on here with the supporting arguments is that the advocate here, the lawyer who's representing Crystal, has chosen to argue each circumstance in the order in which it appears in the rule. The first subsection addresses the nature, condition, and location of the land circumstance. The second subsection of the argument, subsection B, focuses on prior similar incidents. The third subsection focuses on the third circumstance, the prior actions of the assailant. So the argument is tracking the rules organization. Now, you can do that, but if you don't need to do that, in other words, what you're looking for in these circumstances usually is trying to determine, will the judge expect me as the lawyer who's writing this brief to argue my points in the order in which they appear in the rule? As I mentioned in the class, that takes some thinking, usually talking to other lawyers who have filed briefs before the judge to talk to them to see, how does this judge like things to be done. The other thing you have to look for is a threshold issue here. In other words, do we have to show one of these circumstances that are listed in the reasonable foreseeability test before we get to the others? I think the answer to that question is no, because this rule, this reasonable foreseeability rule, is a factors rule. It's not an elements rule. So the court's going to be considering the factors as a group rather than each one separately. So the plaintiff to prove reasonable foreseeability, the plaintiff to prove reasonable foreseeability is not going to have to argue one particular factor up front. Right? Because of that, you have some flexibility to determine which order you're going to argue these factors in your brief. Okay? So we talked about two ways of doing that. One is to start with your strongest supporting argument, then go to the second strongest supporting argument, and then go to your weakest supporting argument. That's one way you could do it, where you start off strong, you keep going strong, and then you end with the argument that is your least strongest point. But that's still necessary for you to make, one that you can't ignore. The second way you could do this is you could start with your strongest point, you put your weakest point in the middle, so you're putting it in the middle that kind of is a way to de-emphasize it, and then you're ending with your second strongest point. So you're starting with a strong point and you're ending with a strong point. Either one of those techniques is fine. So let's talk about whether the advocate's decision here to track the rules order rather than think about what is the strongest point, what's the next strongest point, etc., was an effective way of organizing the argument on a large scale. So the first argument here, the first factor being argued, is the nature, condition, and location of the land. In other words, in what kind of neighborhood was the music box located? You know, and the way this factor works is if a landowner's establishment is in an area where, because of what's happening in the area, not just at the landowner's establishment, but in the surrounding area, it is dangerous, and therefore it's more foreseeable that somebody who's at the landowner's land might be harmed. All right. In this case, the facts that we have show that the area where the music box was located was an area where criminal activity was present. The evidence revealed that there was prostitution and gambling going on in that neighborhood. There was also, I mean, for the most part, and there was no evidence in the record that those prostitution and gambling crimes were violent crimes, okay? But there was one incident that occurred in the alley behind the club that was a robbery where a bartender at the club was held to the ground at knife point while the robber took the bartender's wallet. So there was one crime, at least, that was a violent crime. So on the whole, this is probably not the strongest circumstance for Crystal. You know, in other words, she's going to say, well, maybe, or I think a plausible argument could be made by Richie, the plaintiff, that maybe Crystal could have foreseen the attack at the club here because there's lots of crime in the area. So I would say this is probably the weakest of the three factors for Crystal. So I probably would not have presented this factor first. I would have presented it somewhere else, either as the last section of the argument or in the middle. Okay, the second point that's presented here relates to the prior similar incidents factor. Okay, and the way this factor works is if there are prior incidents at the club, in other words, prior attacks at the club that are similar to the attack that resulted in the plaintiff's injury, that makes it more foreseeable that the plaintiff's injury would occur. And therefore, the landowner should have taken precautions to make sure such attacks didn't occur again. Okay, so I think this factor is stronger than the location of the land factor because we have prior similar incidents in this case, but none of them are, I would say, substantially similar. There was one incident where one patron cut another one with a razor blade, but that resulted in superficial injuries. And the rest of the prior incidents were all fist fights. I mean, so, and they're all fist fights that didn't result in any kind of serious injury. So I think Crystal can make an argument that while she could have foreseen fistfights, she probably couldn't have foreseen a knife attack, which is the attack that occurred in this case. So this is a stronger argument than the argument about the location of the club. But whether I think it's the strongest argument is probably disputable. I think the last argument that the advocate presents here, that focuses on the assailant's prior actions, is probably the strongest argument. But it's presented last. And that's probably not something I would have done. If I would have led off the argument with this particular point, because under the facts of the case, what happened was Broad did have an argument with Ritchie in the past where he threatened to destroy Ritchie, but everybody involved in that confrontation, and Crystal witnessed that confrontation, everybody took that threat to be a threat to harm Ritchie's career as a musician, not as a threat of physical assault, right? So there really was nothing that Broad did at the club previously that would have indicated to Crystal that he was actually going to put Ritchie in physical danger. All right, so large-scale organization-wise, I think unless the judge would want the brief's argument to track the factors in the order in which they were presented in the rule, I wouldn't have used the large-scale organization that the advocate here did, because it doesn't really highlight the strongest points for the advocate. And we'll come back to that. So here's another logical place for a pause. So I'm going to take a very brief breather here. You can pause the video and go off and take a rest, and then we can come back and start to talk about how the advocate frames the law and frames the facts, because that is really important thing to do. It's different from how you frame the law in an objective document like an office memo. So let's pause here, and then we'll come back. Okay, we are back. I want you to go back up to the roadmap section of the brief, which starts on page 3, and talk about how, to the extent that you can as an advocate, you want to frame the rules of law that you're applying in a way that's favorable. In other words, you want to emphasize portions of the rule that favor your client, and you want to frame them in a way that states what the court should do. All right, so I want to show you some examples of how the law is framed neutrally here rather than assertively. So you want assertive framings rather than neutral framings. So here's the first example. Let's look at the first sentence of the roadmap. This is statement of the motion standard. It says this court should grant Crystal summary judgment if there is no genuine issue as to any material fact, and she is entitled to judgment as a matter of law. So I want to highlight this word if here, because in persuasive writing, when you're talking about the law, that word should be, I don't want to say a red flag, but a caution sign for you, a caution sign. Think of it as a caution sign. When you see if in your framing of the law, you ought to think if there are ways, or you got to think, see, I'm using if there. You got to think about whether there are ways you can do a better job of framing the law in an assertive way. All right, so if is a caution sign for you. Now, that's not to say that you always have to reframe your statement of a rule if you're using the word if. That's not what I'm saying. It's just that sometimes the way that it's used results in a neutral framing of the rule, because this first sentence doesn't tell the court, or doesn't strongly suggest to the court what it should do. It gives the court an option. It says, court, you should grant summary judgment if there's a genuine issue of material fact. Not, court, you should grant Crystal summary judgment because there's no genuine issue of material fact. And we'll come back to how we could reframe this in a little bit. All right, let's go to page 4, and I want to look at the second full paragraph here. So we're starting at this paragraph that starts with the word yet. Okay, so this is a statement of where we're getting into when, a statement of the law when we're getting into when a landowner owes a duty of care to an invitee on the property. And the good thing that this paragraph does is it starts off by stating a favorable component of the law, emphasizing that a landowner does not need to ensure the safety of invitees who are on the property. In other words, this is the negligence rule. The duty part of negligence isn't an always thing. It depends on the relationship between the landowner and the invitees. And then we get more statement of favorable legal principles here. This is the framing of the reasonable foreseeability rule, at least the general part of the reasonable foreseeability rule. That I'm going to unhighlight this because I want to highlight a good emphatic use of the word here. More specifically, when an invitee's injury is caused by the criminal acts of a person besides the landowner owes a duty of care to the invitee only if the landowner could have reasonably foreseen the invitee's injury. So the word only is intended to signal to the court that this rule is a narrow rule, not a broad one. So this is a pretty good placement of favorable legal principles at the outset of the paragraph here, highlighting that the landowner's duty to invitees is not broad, particularly when the invitee is injured not by the landowner himself or herself, but by somebody else on the property. That the duty extends only if the landowner could reasonably foreseen the invitee's injury. So when you're framing the law, look for, and this is if you're representing the defendant, okay, who's trying to argue against liability. If you're representing the defendant, look for statements in the law that tend to cast what the defendant has to do narrowly, not broadly. Conversely, if you're representing the plaintiff, look for statements in the law that cast the liability of the defendant broadly. You know, what about the law states that the defendant's responsibilities to the plaintiff are broad, they're wide, they're going to encompass lots of activity. So look for that, and that's going to depend on what the law says. This is just an example of where the defendant could cast the law narrowly by saying this is a narrow duty. All right. One thing I wanted to highlight about the roadmap that I didn't before was this last paragraph. So your roadmap ought to include the motion standard, a statement of the general legal principles. Those are the first two things. The motion standard is number one. The statement of the general legal principles is number two. The third thing that your roadmap ought to state is the preview. This is why it's called a roadmap. You're previewing the points that are coming up in the argument. So that's what this last paragraph of the roadmap does. It previews the arguments that are coming up. It's basically a summary and a preview. So that's a good thing to do because that helps guide the judge through the argument. All right. So those are some examples of favorably framing the rule and the preview section of the roadmap portion of the argument. All right, I'm going to pause here again to give you a break, and then we will talk about the use of CREAC to organize each supporting point. So go ahead and take a breather. All right, we are back. So we are going to start on page 5 and look at the first subsection of the argument. This is the subsection of the argument where the advocate has decided to focus on the nature, condition, and location of the land factor. In other words, is the area where the club was located one that was dangerous and thus should have signaled to Crystal, the landowner, that there was a good chance Richie, the plaintiff, would be injured on her property. All right, so each supporting point in your argument should follow the CREAC format. And that was something I asked you to examine in the Persuasion Through Logic exercise. So let's look at this. First part of this section is the conclusion. And that's this first sentence right here. The location of the land where Richie's injuries occurred certainly did not make his injuries reasonably foreseeable to Crystal. In general, I think it's a good assertive framing of the conclusion. So the tone here is good. But I think there's a problem with one word in this sentence. So let me reverse the highlight and show you which word I think is problematic. It's this word certainly. I think that's the use of that word is overconfident, that it paints this factor stronger than it really is. As I talked about before, this location of the land factor, I think, is probably the weakest factor of the three. So you as the advocate don't want to overplay your hand. You want to assertively state your conclusions, but you don't want to overstate your conclusions. All right, so I would take that word out and just say the location of the land where Richie's injuries occurred did not make his injuries reasonably foreseeable to Crystal, because you're not overplaying your hand. You're not saying this is clearly the case. You should only say clearly or obviously or certainly if it is 100% positive that your position on a point is the right one. And that is certainly not the case with this factor. So you want to be assertive, but you don't want to be misleading and overstate your point. All right, the next thing that should come is the rule. So this is our rule statement. If a landowner's property is located in an area not known for violent crime, that location alone is insufficient to alert the owner of the possibility of criminal activity on the property. So again, I think that's a pretty good framing of the rule. It says, if it suggests that if Crystal's property was located in a bad part of town where there's violent crime, then she is going to have a duty. But it's framed the other way around. It's framed to elicit a yes answer from the court. So it's framed as an area not known for violent crime. So this is a pretty good framing of the rule. For the next thing that should occur, so I'm going to unhighlight that. The next thing that should come is your explanation portion of your CREAC, where you discuss a case that involves similar circumstances so you can illustrate to the judge how the rule functions in a similar case. That suggests to the judge that it should do the same thing as what happened in the precedent case. And you may note this section of the argument is pretty short. Well, one reason is because there's no explanation here. After the statement of the rule, there should be a discussion of what happened in a case where there was property that was not located in an area known for violent crime. And there's no discussion of that. So what the judge is left with here is no context for the rule, no illustration of how the rule works. And that decreases the persuasive impact of the argument. So if you have a rule that's not crystal clear on its face, you should illustrate how that rule works with an explanation portion of your CREAC, where you discuss the relevant information from a precedent case that applied the same rule in the same circumstances. And then the last thing that should happen is the application. There is an application here. This is the last part of this CREAC. And we'll highlight that whole thing because it also includes the conclusion for the CREAC. Or we'll call it a crack because there's no E in this CREAC. So here we have the argument that the music box's location would not have put Crystal on notice that Richie would be injured by his assailant Broad. So there's a concession here that the neighborhood's not crime-free, and that's a good concession. All right, so let me unhighlight this because I've shown you that this is your application and conclusion, and highlight this phrase here. while the music box's neighborhood is not crime-free. And the rest of the sentence then says the crimes common in that neighborhood are only non-violent vice crimes such as prostitution and gambling, not violent crimes like assault or robbery. So what the advocate's trying to argue here is, look, we know that the neighborhood's not crime-free, but it doesn't have the same types of crime as the crime in which Richie was injured. And therefore, Crystal could have reasonably foreseen the nonviolent crimes occurring in the neighborhood, but the neighborhood would not have allowed her to see violent crimes like the one that caused Richie's injury. So, talking about this sentence, you note that in the sentence, I'm unhighlighting here, that the front part of the sentence discusses the negative information. In other words, the admission that, look, this isn't a crime-free place. That favors Richie, the fact that this neighborhood's not crime-free. So what the advocate is doing here is putting this part of the application, this argument, in what's called a subordinate or dependent clause in the sentence. In other words, this part of the sentence, if it were just by itself, could not stand alone as a complete sentence. That's how you note a dependent clause in a sentence. It can't stand by itself as a sentence alone. It's placed right up against favorable information in what's called an independent clause. So this last part of the sentence, the crimes common in that neighborhood, could stand by itself as a sentence if we chopped off the front end of the sentence. So this is a common technique it's called juxtaposition. You are placing unfavorable information in a dependent clause right next to favorable information in an independent clause in the sentence. Why is that being done? Well, readers tend to focus in a sentence on the independent clauses, not on the dependent clauses. So the dependent clause here, while the music box's neighborhood is not crime-free, that's intended to draw attention away from the negative information while still acknowledging the negative information. Right? So that's something that you'll often see happen. It's a little side note on persuasive writing style that we'll revisit in a week or so. All right, so and then this last part is more application and conclusion. I've already indicated. Because of the fact that there were vice crimes in the neighborhood, Crystal could have reasonably foreseen those kinds of crimes, but not violent crimes because violent crimes weren't common. All right, so with this CREAC, it follows the basic sequence that you should follow when you're arguing a point in a subsection of your argument, and that it presents the law and then applies the law. But what's missing in this section is the explanation. Now, I'm not going to go through the other two subsections of the brief because they do follow the CREAC format, because there are explanations there. So let me just talk about this really quickly as an example. Let's actually go to the third subsection, where we're talking about the prior actions of the assailant factor. You have conclusion. Broad's prior actions at the club did not make his attack on Richie reasonably foreseeable. So you have the conclusion for this CREAC there. Okay. Then you have rule. Actually, you don't have rule. Forgot about that. So this is actually, this CREAC is actually missing a rule. But what it does have is an explanation, right? It explains how this factor works by talking about a case that involved a similar context. So it talks about this other bar fight case where the defendant owned a bar, and the decedent in that case, the person who died, so this is somebody who the plaintiffs were representing in the trial, was shot by another patron at the bar. However, they didn't have any interactions before the shooting. So because they didn't interact with one another, the bar owner had no idea that they were hostile towards one another, and therefore the bar owner couldn't have reasonably foreseen the shooting. So what this description is intended to do is give the judge an idea of how the rule works in a somewhat similar context. It's not exactly the same because the plaintiff, Ritchie, and his assailant, Broad, did interact with one another in this case, but they didn't interact with one another in a way that was indicated violence. Maybe they were a little hostile toward one another, but they did not get involved in any kind of violent altercations beforehand. So just like there was no indication that there would be any violence in Merchants National Bank, there wasn't any indication that there would be violence here because of the lack of violent confrontations between Ritchie and Broad. But the rest of this CREAC follows the CREAC format. This here, this paragraph at the bottom of page 8, this is application, where we have the advocate drawing parallels between the precedent case that the advocate just decided and the facts of this case. All right, I'm going to do a pause again here to give you a chance to take a break. And then we're going to look at an improved version of this brief, specifically the argument, so you can see what we're doing. But so let's take a break, and then we'll come back to that. I'm going to close out this document in the meantime. Okay, let's resume here. So this is a so let's talk about I have an improved version of the brief. We're going to focus on the argument, but I want to focus on how you might outline this argument on a global level so you can see this more clearly. So the point headings are the same substantively as they are in the sample trial brief. So I'm not going to go over those substantive points. But I want to just show you the outline in large scale and small scale here. So the large scale organization has to do with in what order are we including the supporting points. So we have our main conclusion up here, of course. That's the same as it was in the sample trial brief. But if we're going to do a better job of persuading through ordering our points here, when we don't have a threshold issue, which we've already talked about, and the judge isn't going to expect you to discuss the points of argument in the order in which they appear in the applicable rule, which we've already agreed is the case. We started off the argument here with the first supporting point, which is the strongest, arguably the strongest point that Ritchie has. So the first point that's being focused on are the prior actions of the assailant factor. So we're looking at, did the assailant do anything on previous occasions that might indicate that an attack by that assailant was reasonably foreseeable? And here, that's not the case. As we mentioned before, Broad, vaguely made threats about Ritchie's musical career, but he didn't threaten him with violence. So that would have indicated lack of foreseeability. So strong point is first. The second point, supporting point in the argument here is the weakest point. So we're putting the weakest point in the middle, and that's because readers, when they read arguments like this, tend to give the least focus to what's in the middle of the argument. So this is the location of the land factor that's being argued here. In other words, what was the neighborhood like where the club was located? So that is placed second. And then the third point is what's arguably Crystal's second strongest point, which is the prior similar incidents factor. So that's placed last because the advocate wanted to end the argument on a high note here. So we wanted to place a relatively strong point at the end. And you note within that, I'm not going to go back over this in huge detail, but each of these points is organized under the CREAC model. So then, and that's what you want to do with your supporting points. And then the last thing here is that there's a global conclusion in the conclusion section. We didn't look at the sample brief conclusion section, but the conclusion section was rather cursory. It was just one sentence, and you want it to be more substantive than that. So we're going to look at that in the improved version. So there's this handout here that gives you a short form global snapshot of what the improved version of the argument looks like. I am going to close that out, and we'll come back to this particular handout, but I want to show you the sample brief here that's in the improved version of the brief and talk about the argument section and show you where some improvements have been made in the argument. All right, so the old sample brief began with a statement of the motion standard. I think it's better, if you can, to start with a statement of the law. Okay, in other words, what's the substantive law that you're applying in this argument? And that's the duty rule. And notice how this rule is framed. And it has to do with word choice here. So we're emphasizing failure. We're saying, look, Richie's not going to be successful. That's what you want to emphasize in an advocate. So Richie's negligence claim fails unless he shows that Crystal owed him a duty of care. That's what the first sentence states. So I think it's a really good, strong starting statement of the law. It's framing the law assertively and in a way that frames the duty narrowly because it's emphasizing failure. The claim fails unless he shows this narrow duty of care. All right, and then I want to talk about, we talked about the use of the word if to frame the motion standard in the previous brief. The previous brief said this court should grant Crystal summary judgment if there is no genuine issue of material fact, blah, blah, blah. This instead uses the word because. So this is telling the court, suggesting to the court what it should do. This court should grant Crystal's summary judgment because there is no genuine issue as to any material fact, da-da-da-da-da. That's a more persuasive and assertive framing of the motion standard because it's saying to the court, this is what you should do. And let me talk about the use of the word should here really quickly. You want to be assertive with what you're suggesting the court should do, but you don't want to be pushy. So when you're asking the court to do things and you're stating that assertively, use the word should, don't use the word must unless the must statement relates to a mandatory, undisputed duty on the court's part. So here we're using should because, of course, Richie's going to argue that Crystal did have a duty of care. So we're signaling to the court that this is a disputed issue, of course. Whether summary judgment should be granted is in dispute. So we're saying should instead of must. But we're still being assertive because we're using because to frame the motion standard. We're saying you should do this because Richie's arguments don't meet the summary judgment standard. Okay, let's look at the next sentence then. And this is another example of dependent clause juxtaposed against an independent clause. So this has to do with the scope of a landowner's duty of care to invitees. And again, the previous brief did a pretty good job of framing this duty, although I think this is a little bit more concise job of framing it. So we have dependent clause, which talks about the duty of landowners to invitees in general. But it frames it in a dependent clause to draw the emphasis off of it. Although landowners normally owe business invitees a duty to exercise reasonable care, then we have independent clause, which focuses as the main focus of the sentence. Landowners are not required to ensure the invitee's safety. So what this does is it draws the emphasis away from the broader general duty and focuses the reader's attention on the more specific duty, which is narrower. And then this word indeed is used as a word of emphasis. And this is, again, used to signal to the reader that this is something the judge, the reader, ought to pay close attention to. And the rest of this sentence frames the law as it was framed in the previous version of the trial brief. But it adds indeed to emphasize the narrowness of the duty and only is used again to emphasize the narrowness too. That the word only was used in the previous brief. So when an invitee's injury is caused by the criminal acts of a third person besides the landowner owes a duty of care to the invitee only if the landowner could have reasonably foreseen the invitee's injury. So the paragraph begins here, which is, I think, a really good, effective framing of the law by emphasizing narrow rule, narrow rule, narrow rule. That's what it's doing. This is the duty is narrow. it's not going to be a usual thing to find a duty of care on the landowner's part when the invitee is injured by somebody other than the landowner. Okay. And then we've already talked about the reordering of the points. So this point A was originally point C. In other words, the last point in the previous version of the brief. This is Richie's strongest supporting argument, so it's presented first. That's good. One of the things that was missing from that section of the brief, however, was a rule. So this is the argument that focuses on the prior actions of the assailant. Did the assailant do anything in front of the landowner on previous occasions that might indicate that the assailant would attack the plaintiff? And this is a good factor for Crystal, the bar owner. But this part of the argument didn't have a rule. So this one does. This draws it from this Merchants National Bank case. The rule basically is previous altercations between invitees in a landowner's presence may indicate to the landowner that injuries to one or both invitees are reasonably likely in the future. So this is saying, you know, if the invitee, if the plaintiff invitee gets into a fight with another invitee, that might indicate a duty. But the word may here is used, again, to highlight the narrowness of the foreseeability that would occur. And that the reasonable foreseeability is not often going to happen in these circumstances. All right, so we have a rule there where we didn't have a rule before. And then I want to go to point B, because this was originally point A in the original version of the sample brief. So, but we decided to put it here in the middle because this is the weakest point. So it's buried in the middle. It's a portion of the brief where the reader's not going to usually focus as much attention as the beginning and end of the argument. All right. Remember, this is the discussion of the location of the land factor. In other words, did the area where the landowner's property was indicate, because of its nature, that the plaintiff invitee would be injured? All right. And in this case, the argument is, look, this is in an area, the club's in an area where there wasn't any violent crime, or there was very little violent crime. So that type of crime wasn't foreseeable. What was missing previously from this portion of the argument in the CREAC was the E, the explanation. So that is included here. A discussion of the Basicer case, which illustrates this factor. That case involved a restaurant where a robbery occurred, and the plaintiffs were at the restaurant and they were injured during the robbery. So they were injured not by the landowner himself or herself, but by other people who were at the property. And the court examined the nature of the land factor in that case and said that that factor did not give rise to reasonable foreseeability on the landowner's part because the restaurant was in a neighborhood that wasn't violent. There's no violent crime there. So therefore, because there was no violent crime, it's unlikely that the owner of the restaurant could have foreseen violent crime occurring in the restaurant. All right, so we have a gap filled in there in that CREAC. And then, as we've already noted, point C, that was originally point B. So this was originally the middle point of the original sample brief. Now, in this improved version of the brief, it is the last point because it's the second strongest point. It's a relatively strong point for Crystal, the club owner. So the advocate here wanted to go out on a high note, wanted to end on a pretty strong note. So that's why this point is being presented last. Okay, last thing I want to let you know is among the handouts that I have posted on Twin. So I've posted everything that I've talked about in this video. I've also posted this handout. They're all in the handouts page of Twin. You can download them all there. I've posted this annotated version of the argument section from the improved brief. And it's a running commentary in the margin of a lot of the things I've already talked about. It talks about the large-scale organization. It talks about the small-scale organization. So you can see what's going on in each part of the argument section. One thing I didn't talk about that I want to go to the end of the handout, and this is also in the improved version of the brief, is the conclusion section. So your argument, or I'm sorry, your brief ought to end with a conclusion section that has a recap of your argument sections that just summarizes the points you previously made in the argument section and brings the reader back around to the main conclusion. So that's what this conclusion section does. It summarizes each supporting point of the argument and then returns the reader to the main point, which is no duty of care and thus no negligence. And then it returns the reader back to the main procedural request for a remedy, and that's summary judgment. We want you to grant summary judgment. Okay, I hope this video has been helpful. I am more than happy to answer questions about what I just talked about in it. We will, in future classes, talk about some of the style techniques, for example, using dependent and independent clauses. We'll talk about those in more detail in future classes, just to get into more depth with regard to how writing style can be used to persuade. So thank you for your patience. Again, I hope you're safe and warm someplace on the cold day when our class was canceled. And that is the end of this video. Thank you.